Hello, welcome to today's immigration tidbit. This is really a jurisdictional issue. The fact is that immigration is not supposed to hand over things to ICE, CBP or DHS. That's just a fact. They're not supposed to do it. But depending what jurisdiction you are, they are very cooperative with immigration. You can probably guess the jurisdictions that are not a problem, and you can probably guess the jurisdictions that are a problem. If you happen to be caught doing something in California, or Oregon, the Ninth Circuit, you will not see the local authorities sharing anything at all with ICE. Okay, that's just the reality. They have to do their own work. They have to file their own detainers. They have to do their own timings as to when to pick up the person, put a hold on them and so forth. They have to do it all within the book, or the person, assuming they're not later, incarcerated or booked, they'll be set free. But if you're, in Texas or Florida, one of those jurisdictions, the 11th Circuit, 5th Circuit, and so forth, the police may very well not only share the information, they may jump the gun and give the information without even being prompted. Obviously, that's unfair. There's racial issues with that. There's profiling issues with that. There's pure racism with that. But that's the reality. Now, given that, if you figure that you're going to have to fight your immigration case anyways, you may as well take care of business and do what has to be done. The fact that they may share information with immigration doesn't stop you from doing what needs to be done. So, for example, if you're in Texas and you're pleading guilty to something, let's say theft, burglary, whatever, you want to have an immigration attorney with you or advise you on what you should and shouldn't plead guilty to, because if that person's knowledgeable about removal proceedings and so forth, it may not stop you from being placed in removal proceedings, whether or not the authorities are notified. But it may help you, if the plea is proper, to win a removal proceeding. So the focus of your question, I understand it, but the focus should not be on what they do or don't disclose to U.S. immigration agencies. The focus should be on how you can win an immigration case. So when you're saying, police finding evidence of immigration violations, it's hard to fathom at the moment what exactly that might be without them, unlawfully doing things or profiling. Obviously, if they come to your door, and I'll exaggerate, if local police come to your door, knock, and say, "I want to see your green card," okay? They clearly would not say that to a U.S. citizen, okay? Because the U.S. citizen, number one, doesn't have a green card and doesn't need a green card. And the police, the local police, they don't have jurisdiction to enforce immigration laws. The governor of Texas believes otherwise, but the courts will ultimately and eventually shoot that down, because you can't having states acting as, lone star authorities to do what they want, enforce what they want, and have the whole immigration system upended because they believe they want to proceed on their own. It's not how the law works. So, other than just absolute blatant finding of things that would be in a normal search for a normal violation, Again, it's hard to see what specifically they would find where they could point to the fact that it's immigration without any type of other evidence. I mean, again, they might say, "Let's see your ID." Okay, that's a possibility, and the person might not have an ID. Well, if that's the case, and they need to have an ID, and there's a local or state violation for that, then that's what would be prosecuted, not that they are illegal or unlawful. Okay, again, that's up to U.S. immigration. Okay?